Welcome back, everyone, to Morning Line. Nick Beres here, along with Vanderbilt Professor James Blumstein. Nice to have you on, sir.
It's great to be with you.
My learned guest, just sit and listen, but as I suspect, especially talking about the Supreme Court decision on same-sex marriage, we got some calls here, so the lines are open. This and other decisions we can talk, but let's take Joe. Joe, good morning.
Good morning, Nick.
Hey, Joe, go ahead.
This just goes to show you that even the Supreme Court can't come to an overwhelming decision on these matters that's come before them. They can't even agree on it themselves. But if you go back through history, all of our great societies in the historical past have been brought down within. And this stuff is coming up. It seems like it's headed in that direction. This is mostly religion against the Supreme Court. So, where you believe in the Bible or where you believe in the Supreme Court. So, we facing some real problems in this country, the way I see it.
Well, we'll see. Now, it was a 5-4 decision, so it was close. Can you maybe articulate what you saw as being maybe the chief objection from those dissenters?
Right. The key question for the dissenters was who should be making this decision. Right. Should it be made by the people in a democracy, or should it be, in their view, imposed by the court? And I think that the court has put itself in the position of identifying what is a fundamental liberty. And from the dissent's point of view, making up this is that all the language in the past about the fundamental nature of marriage all assumed heterosexual marriage. And so, as I like to tell my students, the question is, what's the level of generality at which you determine a fundamental interest? Is it marriage in general, or is it same-sex marriage? And what is fundamental? If you look at the lower level of generality, same-sex marriage, the court's decision makes no sense. Only if you raise the level of generality to marriage overall can you make the claim that it's fundamental.
That's what Kennedy did.
That's what Kennedy did, is he said, let's look at overall marriage, and then let's determine what it is that makes marriage fundamental, and does that apply to same-sex couples, or is there something separate? And he had to overcome the question of whether procreation was at the center of traditional marriage. And what he said is, no, it's not. It's an important value, but it's not the only value. It's not the preclusive value. The ability to have children is an important part of what marriage is about, but it's not the only part. The dissenters saw procreation as the centerpiece, the ability to procreate, and in a sense curbing males to make sure that the odds are that a child will be born to a couple, so that the father is known, the mother raises it, the father has obligations, and he knows the child is his, and that marriage is really a way of circumscribing and assuring that the man will be part of the family and will be clear whose child it is, basically, and that we'll have responsibility for the child. And the majority said, no, it's more a question of affirmation of loving relationships. There are certain material and non-material, more spiritual values of that. And so the question then is, how do you determine what is fundamental? And in the past, the court has said we should look to a careful description, which means a low level of generality based on history and tradition. And Justice Kennedy, for the majority, said that's okay, that limits our discretion, but it doesn't end our discretion. We have the ability to have a living constitution, to update, as he said, as more values are revealed to us, we get greater insights. We as a court can identify those fundamental liberties and expand the scope of liberty.
Which they've done, and they've expanded. Now, again, some critics who I think are going away from the fringe are saying, well, the next thing is you're going to be able to marry your dog. Or the next thing is you're going to be able to marry the tree in your front yard. I don't know. You know what I'm saying? Talk about why. I know that's not what Kennedy is talking about here, but some people say, oh, it's slippery slope. What's to stop that from happening? Which I think is absurd. But
yeah, well, a little also tongue-in-cheek, but one could ask, can the 9 justices of the Supreme Court say, we're one big happy family, can we get married?
Yeah, exactly. Right, so there are limits.
And so, I mean, I think there will be some sense of practicality and common sense involved in this. But overall, kind of the posture of those who won the case. They really won a big victory. It was 5-4. The caller is right. It was a split court. Not so much on the question of same-sex marriage, but on the question of who should be deciding. You know, is this something for a court to decide, and what does this mean into the future about recognizing rights that are only implicit, they're not expressed in the Constitution, where the court is reading into the Constitution certain fundamental rights and liberties. And I think the court tried to come to grips with this. It certainly analytically reads more, it's more satisfying, but the dissenters have a point. As I read, took me almost all day yesterday to read this thing. I kept saying, well, that's a good point, here's a problem, and I read the dissent and said, that's a good point, here's a problem. I kind of read through it, and there were a lot of good points that were made by all sides. But I think the real test of leadership going forward for the gay community is going to be the leadership principle of magnanimity.
Let's talk about that in a second, because I want to talk in more detail. Let me squeeze in a few more phone calls, but I think that's an excellent point. We've got to talk about what you mean by that. Let's go to Tommy. Hi, Tommy.
Good morning, Nick.
Good morning.
I just have a couple of comments, actually. First, I think the majority of the people in this country actually feel like that these Supreme Court judges should not be appointed for basically life to be sitting on the court. But anyway, I feel like that 9 people, it seems like that they feel like they know more than the majority of the people in this country on certain issues. Now, on this of the same-sex marriage, I feel like that should have been left up to the state, that the people should have the right to have voted on it. But I will say this, the 5 that voted for it, for the same-sex marriage, what they're actually saying is that they actually know more than God. And if you read your Bible and you study it, then you'll know exactly what I'm talking about. And that's a scary thing to fall into that.
All right, hang tight, Tommy. Do the Supreme Court justices, do they take God and religion into account when they make their decision, or are they interpreting the Constitution?
Well, in theory, they're interpreting the Constitution. And the court in an earlier case from 2003 had said that moral values in and of themselves are not a sufficient basis to legislate. There have to be what are called secondary consequences. So this case doesn't come out of the blue. There were building block cases, and the most important one was when Texas made illegal same-sex sodomy. And the court had to determine whether the government could make a criminal offense out of intimate personal conduct that was inherent in a same-sex relationship. And the court said, look, there's no evidence that there's harm here to anyone as long as they're adults and consenting
adults, yeah.
And it's not appropriate for the government to legislate purely on the basis of morality. There have to be secondary consequences. There has to be a harm to someone. And they left open in 2003 the question about marriage. Very clearly, they say this does not deal with same-sex marriage. Now, Justice Scalia, in his dissent in 2003, said, well, I don't know how you distinguish same-sex marriage. And he turned out to be right. But it took 12 years for that to percolate through the system. But the court in 2003 made it clear that marriage was different. And I think what they were waiting for was evidence that same-sex marriage would harm somebody. But the court relied upon studies, social science studies, and these are now contested, that same-sex couples are no worse and no better at raising children or having divorces or having relationships than heterosexual couples. You know, marriage is an imperfect institution. The divorce rates are higher than one might hope. Now, one other benefit that comes, if you want to look at this from a benefit point of view, is that I thought one of the real problems from my perspective of where we were before the case is that people could marry in states that recognize same-sex marriages. If they'd moved to a state like ours where same-sex marriage is not recognized, then there's no procedure for divorce if they fell out of love or they wanted to have a divorce. So people in California, New York, wherever we get married, same-sex couples come to Tennessee, want to change partners or at least disengage from their partner. There was no tool to do it because it's easy to go to a state and get married. It's not, you cannot just go for a weekend to Nevada and get a divorce. You have to establish what's called domicile or residency in that state, and so it's very difficult. You have to give up your job, you have to move there, be able to say that you're going to be there indefinitely, and so that issue is a real poignant issue, that the states that didn't recognize same-sex marriage, that was really something they had to confront. Now that problem's gone away.
Yeah, it's gone away, and in fact, this week scheduled are several same-sex divorces here in the state of Tennessee. Those are underway as well, not just marriages. We'll take a break on that note when we come back. Greg, Taylor, Philip, Tony, and others, they all want to talk to you. We'll take a break and be back with more right after this.